Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. In this video, I am going to give you a brief introduction regarding jurisprudence, third semester. Jurisprudence is a Latin word derived from the Latin. Jurisprudence is derived from the Latin word jurisprudentia. Juris means law. Prudence means skill, right? So, skill in law or knowledge of law. Jurisprudence is knowledge of law. So, normally you are here to learn so many acts, so many provisions of law, all these things. Because they are already there, you are happy to learn them. But what happened before making this law? Will be known to you if you study the jurisprudence. So, what is the history behind making the law? How the law has come up? So, who are the thinkers of the law? This is what you have to learn in jurisprudence, right? So, whenever you study the jurisprudence, it is understand that please it is nothing but you are developing skill in law, right? So, jurisprudence is, please remember, it is linked with the social science. So, centuries back, even before Christ also, Plato, his Shishya Aristotle, means the philosopher, they started thinking of law. Of course, they even did not know that it is law. They are thinking the political structure, how the political structure should be there, and how to implement the structure that is by law. So Aristotle, Plato and others, they started thinking. Of course, this jurisprudential development came from the from 18th century, from the great philosopher Jeremy Bentham. Jeremy Bentham, he has created a theory. That theory is called utilitarian theory or pleasure and pain theory. We are going to discuss this in some other videos, because if I start discussing about the utilitarian theory, it will take much more time. Right? Then his Shishya, John Austin, he has started the analytical school. So they are all thinking, no doubt, jurisprudence means the study of the just and unjust, the study of natural and divine principles connecting the society, science and society, principles connecting the society. Then, to control the public, to maintain the law and order, law is necessary. How the law should be? So already Jeremy Bentham told law should be utilized at so many persons, law should give pleasure to so many persons. At the same time, the perpetrators of crime, they should be punished. So that's why pleasure and pain theory also was developed. And the new generation like Salman, he said that law is the aggregate of principles, please remember, which are applied by the state for the enforcement of or for the administration of justice. They are nothing but legal set of rules enforced by the state for the administration of justice. Already you know what is administration of justice and why law is called, a lawyer is called a court officer, and why court is called an place of administration of justice. Right? So, before law, you have to know the definition given by Plato. Plato said, mankind must either give them law to regulate their behavior, to regulate their life. Mankind, they should frame some law. What for? To regulate their behavior or to regulate their lifestyle. Otherwise, they will become or they will live in no better way than the wildest of the wild beasts. So you will just behave. If you do not have law, if you do not create law, you are equal to the beast. The beast means you will be knowing. So it will frown upon anybody. It doesn't know the consequences. It doesn't think what is right and what is wrong. Okay. Then the importance of the study of jurisprudence. Why should you study? Normally, yesterday I think in the class I have explained you, people, the opinions of the students, normally they think that it is a dry subject, doesn't have any act, doesn't have any sections, doesn't have any rules, and doesn't have any use also. But don't be under the wrong impression. Why you have to study the jurisprudence? Because already I told in the class, jurisprudence is the lawyer's extraversion. Extraversion. Introvert and extrovert. Definitely you know the differences between them. If you know the jurisprudence, if you know the grassroots of the law, definitely you can interpret in any manner, and it gives you the so-called power to speak anything about anything before anybody, not only in the court of law. Right? That is lawyer's extraversion. Right? So it is not mere law and something more than that. Not mere law and something more than that. Please remember. And it helps the advocates to put the law in the proper contour. So yes, I told you, sometimes I will be giving directions to you also, that when you have to speak the arguments, submit the arguments, you should know the four aspects. That means you must be able to convince the judge by way of your arguments. You must be able to draw his attention. You must be able to draw the attention of your advocates. And most importantly, you must know which word has to be put at what time. This is more important. That's why language and tenor, they are more important. When you will do it, if you know the law properly. So that's why if you know the jurisprudence, definitely you will put the law in the proper contour. Then it is helpful to the legislators for the purpose of lawmaking. Yes, you all know, by using legislative power, the legislators, maybe MLAs, MPs or MLCs, they make the law. Before making the law, if they know the jurisprudence, if they know the consequences, definitely they will be in a position not to commit any wrong. They will give the beautiful law. Why? Because, please remember, if any law is against the constitution, it will become null and void as per constitution. So for that, they have to know what is against the constitution, what is in consonance with the constitution. So unless you study the jurisprudence, unless the legislators have knowledge of the jurisprudence, it's difficult for them. Therefore, jurisprudence helps the legal, that is law, so-called MLAs or legislators in the lawmaking, and it adds your knowledge. It adds the lawyer's knowledge to your understanding the concepts. For example, yesterday I given the example of that motorcycle case. So 9/10, possession is 9/10 of the ownership. Unless you know the delay, so jurisprudence is very difficult for you. What law says, if anybody takes away the motorcycle from any other person without his knowledge or by putting him under fear, it is theft. Then when he is in possession of the vehicle, can he be the owner? Can he give the complaint? Yes, because he is the temporary owner. He is the possessor. He has got 9/10 of rights. So for this, you have to know the jurisprudence. And please remember, by studying jurisprudence, by understanding jurisprudence, you will be able to understand the theory behind the law making, and also philosophy behind the laws. This is more important. Philosophy behind the laws. Why we are calling all these people PhDs as doctors of philosophy? Because law started, law emanated, law was thought about from the philosopher's stage. Yes, they have started. Of course, they did not start in the name of law. They start in the name of political structure. How the politics should be, how the ruling should be, how the administration should be. But a part of it is law. Okay? So, in the foregoing classes or in the coming classes, we are going to discuss a number of thoughts, number of theories. So, several jurisprudence, they have developed their own schools of thought. We are going to discuss them in the coming videos. So, for the present, I am stopping here. Thank you very much.